Hi, welcome back to another video on A-Level Law, and today we're going to be talking about occupiers liability, which is on paper 2, tort law under OCR, the specification. So we're going to start by making the key distinguisher in this topic, and that is between the two acts that make up the main content for this law, and that is the Occupiers Liability Act 1957 and the Occupiers Liability Act 1984. And there's a key grammatical point there. Make sure you're using capitals for the acts, and make sure you're also putting the apostrophe after the S rather than before the S. So Occupiers Liability Act 1957 and 1984. Now you do need to know the dates here, unfortunately, because they are both, the shorthand title of both acts is the same as Occupiers Liability Act, and they cover two different things. So 1957 Occupiers Liability Act covers lawful visitors, whereas the Occupiers Liability Act 1984 covers trespassers. So you really need to make sure you know the difference between the two, and that's something we'll be exploring today. So what is the difference between a lawful visitor and a trespasser? And that's the key thing. When you first get a scenario, the first thing you want to do is pick out, okay, is the person a lawful visitor or are they a trespasser? And that'll tell you which act to use, and the law is ever so slightly different depending on the act you use. So what we're going to do is start by exploring the 1957 Act, and we're going to go through all of these key sections here. So section 11, 21, 22, 23, 23b and 24. You do need to try and learn the sections. The best answers in the exam will give the sections. Certainly if you know the content of the sections but don't necessarily know the section names, that's not necessarily a problem. That's still getting the main law down. You'll still get very, very good marks for that. But the best thing you can possibly do to have the best possible answer is try and know the sections as accurately as possible. They are more or less in order. You can see there section 1.1 and then 2.1, 2.2, 2.3, 2.3b unfortunately, but then 2.4. So they're not horrific to learn, but you want to try and have a go at that. So what we're going to do is work our way through each bit of this. So starting with section 1.1 and explain the law for all that for you. So starting off, section 1.1 basically states what the main law is under occupiers liability, and this is that an occupier owes a duty of care to lawful visitors with regards to their premises. And I've underlined certain bits there which we're going to need to go through because we need to define what those are. But let's just go through that again. It's an occupier owes a duty of care to lawful visitors with regards to their premises. Now, looking at occupiers liability as a topic as a whole quickly, it's really important you distinguish this from topics such as like negligence and nuisance and Ryan and Fletcher. In those topics, so negligence, nuisance, Ryan and Fletcher, what that is about is suing someone for that particular tort. So it's about suing someone for negligence, or suing someone for nuisance, or suing someone for Ryan and Fletcher. The two other topics you learn on the tort paper are occupiers liability, this topic, and vicarious liability. Now, occupiers liability and vicarious liability is not really about what you're suing for, it's about who you're suing. So in this instance, in most of these cases, someone has been negligent and led to someone being injured or having their property damaged. So they're suing somebody for negligence in most of these cases, and the question of occupiers liability is, can you sue the occupier of land? And vicarious liability, which is a topic we'll do much later, is can you sue the employer rather than the employee? So vicarious liability and occupiers liability is not really about what you're suing for, but much more about who you can sue. So just be careful to make that distinction when you're looking at this and not get confused. So going back to this then, section 1.1, we're saying the occupier owes a duty of care to lawful visitors with regards to their premises. So basically, if the occupier doesn't maintain that duty of care and a lawful visitor is injured or has their property damaged on that land, they can sue the occupier for negligence. It would be in this particular circumstance. So they can sue the occupier if they failed in their duty of care. Now we need to work out a few things here. So for instance, who is an occupier, what is a lawful visitor, and what's a premises? We'll go through those quickly. There's three main cases you could look at for occupier. There are others, but these are three I've chosen. The first one is Wheat v. Lacom, and in this case, a manager of a pub was given permission by the owner of the pub to rent out some of the rooms upstairs where he also lived to paying customers, and one paying customer slipped and fell down an unlit staircase, and her family, her estate brought a claim against the pub in that case to say, well, you're liable for negligence in that case, but we want to sue you as the occupier. And the question there was, well, who is the occupier? Is it the manager who is sort of managing the pub, doesn't own the actual premises but is managing, or is it the owner of the actual premises, the actual owner of the pub who wasn't there or actually doing anything there but actually owned the premises? And it was actually determined that in this case that both could be counted as the occupier. So in fact, the estate could sue either or both, in theory, of the occupiers there, although only, of course, one would probably be held liable. So, in fact, they said that there could be multiple occupiers. Harris v Birkenhead, the council had served what's called a compulsory purchase order on a family's house. Now, that means that they have to sell the house. They usually do it when they want to build like motorways or roads or things like that, and it gives you no choice. That you sell it for market price, etc., and off you go. And the family had actually left, and the council knew this, and the council hadn't actually been round and taken official possession yet. They hadn't boarded it up, which they really should have. And in that time, a child got into the house, 4-year-old child, and was injured in the house, and they actually held that the council were liable in that case because actually they were now in control of the premises. The family had left, they ceded control to the council who'd asked for it essentially through this compulsory purchase order. The family were no longer liable, it was the council. They were the ones that were in control of the premises, or should have been in control of the premises at that point. And finally, Bailey v Arms, a family had owned a flat and they allowed their child to play on the flat roof above a supermarket, essentially outside their flat window. But they said never take your friends on there, but you can. The supermarket knew nothing of this use. They didn't have access to the roof and didn't ever think about it essentially. And one day the child took his friend onto the roof and the friend fell off and was injured and tried to sue. And in that case, they held that neither the flat, the people, the family in the flat, they weren't the occupier because it wasn't their roof. And equally the supermarket, they had nothing to do with the roof. They weren't controlling it or doing anything with it, so they weren't the occupier either. So in that case, nobody was the occupier. So you've got quite a complicated situation here, and there is unfortunately no statutory definition. You think they created the Occupiers Liability Act, you think they would have defined what an occupier was, but they didn't in the statute. They've left it purely up to common law, case law. And in it, we've seen that it's a complicated situation. There can be multiple occupiers, there can be no occupiers, but ultimately it comes down to one thing. It's not necessarily who owns the premises, it's about control, who's controlling that premises. In Bailey v Arms, nobody was. In Harris v Birkenhead, it was really the council's fault. And in Wheat v Lacon, both were, in essence. So it's really more about who's controlling the premises rather than who directly owns it. Okay, so that's occupier. In terms of premises, I'm going to go to next. Again, there's no statutory definition in the statute about what a premises actually counts, but there is a very wide definition in section 13A of the Occupiers Liability Act 1957, which describes it as any fixed movable structure including vehicles. And there's a whole numerous amount of cases that have labelled things such as cars, dry docks, lifts, even a ladder as a premises. So pretty much it includes a very wide array of things, but basically any normal structure would of course be included, or even land or garden be included within premises. Finally, what a lawful visitor and what's the difference to a trespasser? Well, there are key differences in different types of lawful visitors really. You have invitees, which could be invited either explicitly, which you say where someone come around my house, come onto my land, or it could be implied invitee, where perhaps like in shops and stuff, where you have obviously implied permission to invite to go in and shop and things like that. Licensees, where people have a license to be on the land for a short period of time or in the building for a short period of time or a certain amount of time. You also have contractual permission, which is where people have bought a contract or have signed a contract or essentially paid money to be on that land. So the best example of that is you pay money to go to, for instance, like the O2 Arena or into to see a band at a pub or something like that. You have obviously contractual permission because you've paid your money to therefore be on the land, so therefore you're a lawful visitor. There are two other things that you could make you a lawful visitor. And firstly, that's statutory power of entry. So numerous people have statutory power of entry, such as police people, police officers, post people, so postmen, postwomen, meter readers, and people like that really, fire brigade as well. So if there's a fire and things like that, they have the statutory power. They don't have to have your permission. They have power under the law, under statutes actually, to go in and enter your premises without your permission necessarily. And finally, the last thing to remember is entry to communicate. What you've got to remember is someone's front garden is their premises. It's not just their house, it's also the garden as well. So, but everybody has the power of entry to communicate, which means you have the right to go up to someone's front door to communicate with them to communicate with the people inside. So you have the right to go up. So typically people like Jehovah's Witnesses or perhaps political party candidates or salespeople, they have the right to go into your garden. So in essence, they're not trespassing in your garden because they're going to try and communicate with you. Obviously, if you ask them to leave, they have then a reasonable amount of time to leave before they would then become a trespasser. And equally, you can put a sign on your gate as long as it's clear and obvious for no cold callers and things like that, and they would become, if the sign's obvious, they would be a trespasser in your garden if they ignore the sign. Okay, so that's the difference between occupiers, premises and lawful visitors. And remember, an occupier owes a duty of care to lawful visitors with regards to their premises. So you've got to make sure you know all those three things, and I'll go through how you apply that in a scenario later. Section 2.1 says that a claimant can claim for injury or damage to property. So any claimant who's suing the occupier in these cases can claim for injury or damage to property, and that's one of the key differences with trespassers. You'll see that trespassers can only claim for injury, not damage to property, but lawful visitors can claim for both or either. So what actually is the duty of care then? We've seen who an occupier is and what the premises is and what a lawful visitor is, but what does the occupier actually have to do or not do, essentially? And the very simple answer is they have to do what's reasonable to ensure the visitor is reasonably safe on the premises. Now you've got to make sure you get the right terminology there, because quite often what people say is they've got to make sure the premises are safe. That is wrong. De facto you do, but what you've got to do, the duty of care, is to do what's reasonable to ensure the visitor is reasonably safe on the premises. And there's three really nice cases here where the courts have followed a really common sense approach with this, and you'll hopefully agree with these two cases. I'll just go through quickly. But it's to do what is reasonable to ensure the visitor is reasonably safe on the premises, which of course means you've got to keep the premises safe. But the emphasis is keeping the visitor safe on the premises, not keeping the premises safe so the visitor is safe, if that makes sense. Now the first key case on this is Laverton v Kia Pasha Takeaway Supreme. And in this case, the takeaway shop decided, they didn't have to, but they decided to install non-slip tiles on their floor, and they mopped the floor when it was wet and things like that, and put signs up, etc. And on one unfortunate instance, Miss Laverton or Mrs. Laverton slipped and fell and broke her ankle when it was a wet day and busy day in the takeaway shop. She tried to sue them, and the question was, well, the first key things there were Kia Pasha Takeaway Supreme were clearly the occupier because they controlled the takeaway and owned it and ran it and things like that, and they were there and they're in control of it. It was clearly the premises, so that was fine, and she was clearly a lawful visitor because she was invited in, implied permission to come in and buy anything she wanted from the takeaway. So it fits all that bit. So therefore, did they fail in their duty of care? And the answer was no, because they did what was reasonable. They installed non-slip tiles at their own free will, and what else could they have done, essentially, the court said, to keep her from any of the visitors safe? They did everything they possibly could that was reasonable anyway, to make sure that they were all safe. It wouldn't be reasonable to say, well, you can't have people in when it's raining and stuff like that. That obviously wouldn't be fair. So they did what was reasonable, and therefore they weren't liable. Equally, in Rochester Cathedral v. De Bell, this is a huge grounds, and what had happened basically was a car had knocked over a bollard, even very slightly, hadn't even knocked it slightly, causing 2 inches of concrete to protrude from the bottom, and the claimant had fallen over it, essentially, and she tried to sue the grounds of Rochester Cathedral for this. And the court said, it went up to the Court of Appeal, and they said no. They said, trips and falls are everyday occurrences that just would happen regardless of any dangers. And they equally said, it's not a real source of danger here. So wouldn't be reasonable to say they had to fix every 2-inch sort of bit of concrete that was protruding from their grounds all the time. They said that's not a real source of danger, and everyday trips and slips occur anyway. So they said that's not. You couldn't have possibly expected them to fix that. So she lost her case there, and they were not liable because that wasn't reasonable. Equally, in Cole v Davis Gilbert, Royal British Legion, and others. A woman tripped over, got her foot trapped and injured her foot in a hole on a village green grounds, and she tried to sue the owner of the grounds. She tried to sue the council who ran the sort of grounds as well, and also the Royal British Legion, who 2 years ago had a maypole there as part of a sort of festival they did, or a sort of village fair, etc. And she claimed the hole was from there from 2 years ago, which they didn't cover up. She actually won at first instance, but it went up to the Court of Appeal, and they all appealed it together essentially, and as a joint case. And the Court of Appeal actually found for them, actually, the defendants in this case, and said, firstly, the Royal British Legion, you can't say they're liable for 2 years ago, where they used the land 2 years ago. And in terms of the other two, they said, we don't know that someone didn't come along and dig this hole or redig this hole and things like that. It's 2 years ago. They said there's no way that we can't say that it's their fault that they didn't fill in a tiny hole on, someone could have dug that, someone could dig a hole each morning. How would you fix? You couldn't expect them to keep going along and fixing this tiny hole. So they said no, they're not liable. They did what was reasonable in making sure the grounds were mostly, the visitors were reasonably safe on the premises. Okay, so three quite common sense approaches there, I think, and all the question there is, did the occupier do what was reasonable to ensure the visitor is reasonably safe on the premises? And it's just up to you to argue that. In terms of children, there is actually a higher duty of care because, of course, children will be less careful than adults, and that's specifically what the Section 2.3 says. So you have an extra duty to really guard against what are called attractions and allurements, things that kids will clearly go and that could be dangerous, but will clearly be attracted to or allured to. That's clearly shown in the case of Glasgow Court v Taylor, where the council knew there was a poisonous berry shrub on their grounds and they didn't do anything to remove it or fence it round, and a child, I think it was a 7-year-old child, ate the poisonous berries and died. And they said, you've clearly failed in your duty there to keep visitors reasonably safe on your land. You knew children played on the land in this park, and you knew the berry bush was there, so you should have removed it or put a big fence around it. So they were indeed liable. And obviously it's subjective in terms of the age of the child, so obviously you need to do more for a 4-year-old child than you would need to do for a 17-year-old child, for instance, because obviously a 4-year-old child is far more likely to be more at risk than a 17-year-old. So it is flexible depending on the age as well in terms of what you need to do to meet that reasonable standard. However, there is an exception to this, which is Phipps v Rochester Corp, and in this case a 4-year-old I think was playing with a 7-year-old sister out on these trenches in this council occupied land, and one of the 4-year-old fell down the, or sorry, 5-year-old fell down the trench and injured themselves. And in this case they actually said, well, to be honest, the parents were liable, not the council, because they should have been supervising their children. They're young children, they shouldn't have been allowed to play on potentially dangerous land. So actually the parents were liable, not if anyone, not the council in that. Now the problem there is, of course, at what age do you say that actually the parents are no longer liable and actually it's the occupier? And we don't really know there, and that's a good point we'll make in the essay later. Finally, it has to be foreseeable injury or damage. So if the injury or damage that the person sustained was not foreseeable, then certainly the defendant won't be liable. Because if it's not foreseeable, why would you have thought to remove it? You'd only remove things that would cause foreseeable damage or injury. So it wouldn't be fair to hold people liable for unforeseeable damage or injury caused from something that you just wouldn't see. However, in Jolly v LB Sutton, it was an upturned boat. It had been there for 2 years. They'd put a notice on saying they were going to move it in the first 7 days and didn't, and they knew kids played there, and it was clearly an obvious danger and could cause injury, and they didn't move it, and therefore they were clearly liable in that one. 2.3b covers tradespeople, and occupiers owe a common duty to tradespeople on their premises, so they're expected to keep tradespeople just as safe as a normal visitor. However, you can expect an occupier can expect a tradesperson to guard against any special risk associated with their trade. So if they're injured by something clearly associated with their trade that they didn't take precautions against, that's not your fault. So a typical example I give you is just as a made-up example. You ask a plumber to come onto your land to fix your sink. They don't wear goggles where they should, and they're untightening a sort of a screw or something like that, and it bursts out from water pressure and hits them in the eye. Well, you clearly could expect them to know those risks because they're a plumber and know those risks associated, so they should have worn goggles. You shouldn't need to tell them they need to wear goggles on your land. But compare that to an opposite situation where the plumber comes onto your land, you invite them upstairs to fix your sink, and you know your staircase is rickety and about to collapse, and they go up the staircase and the staircase collapses and they're injured. Clearly you would be liable just in the same way as any visitor. It's nothing to do with their trade, is it? So, and you can see that really clearly from the case of Rolls v Nathan. And in Rolls v Nathan, 2 chimney sweeps in the 1960s were injured and died actually from carbon monoxide inhalation in a chimney when they didn't take special precautions. They should have worn obviously special breathing equipment, and they didn't, and that wasn't the occupier's fault. They could expect them to have taken their own precautions within the trade. The final bit on 1957 Act is under Section 2.4, and this is what happens if an independent contractor completes work on your premises, leaves, and then their work injures or damages the property of a lawful visitor. So the last bit, this bit, is where the tradesperson themselves are injured, or another word for a tradesperson is an independent contractor, so where they're injured on the premises. But this bit, 2.4, is where they come and do the work, leave, and then someone else is injured by potentially their work. So the question is, can the occupier put their hands up and say, do you know what, I'm not liable, you should sue the independent contractor, not me? And there's a test for that, and there's 3 parts. Number 1, it has to have been reasonable for the occupier to have given them, the independent contractor, the work in the first place. And you can see that really clearly in Hazeldean v Dorr. They needed an engineer to come and fix their lift, so they hired a company to come and fix the lift. And of course, it would have been negligent for them to do it with no experience of fixing lifts. So actually, it was perfectly reasonable for the occupier to have given the independent contractor the work in that case. Second bit of the test is the person you hired must be competent. So you must have hired someone competent, so you should really be looking for references, or they've got accredited from an association or something like that. They've got proper qualifications. So for instance, if you just went down the pub and got your mate to do it, that clearly wouldn't necessarily be okay. And you can see that in Bottom Levy Todmorden Cricket Club. A cricket club hired just this random amateur stunt group basically to do fireworks. Instead of using normal fireworks, they used gunpowder and gasoline and things like that, and they got this unpaid stunt double with no experience to do the stunt, and he broke his arm and got badly burnt, and he tried to sue the cricket club, and the cricket club were quite rightly criticised and said, well, why did you hire this completely uninsured amateur group? You should have hired someone properly. So actually, sorry, you can't pass liability to the this stunt group. You are liable because you should have hired someone competent. So they were able to sue Todmorden Cricket Club there. They were unable to pass on the liability to the independent contractor. And finally, you must check the work if you can. So obviously, if you go back to the Hazeldean and Door case, there's no way they could have checked that work apart from checking that the lift even worked. They wouldn't know whether it was broken or not, if there was any things inside the actual technology and engineering that weren't fixed properly. There's no way they could know. But obviously, if you can check, you need to. And there's a good case here, Woodward v. the Mayor of Hastings, where they clearly could have checked and should have. And that is where their school hired someone to clean the ice and snow of all the steps and pathways in the school. And they didn't check it after it done, and someone slipped and fell, and they said, actually, sorry, as the occupier, you are still liable rather than the independent contractor, because you should have clearly gone around and checked that it was all clear once they'd done it, just to make sure, because you should have that level of responsibility in a school. So only if all three bits of those are passed. So it was reasonable for you to give them the work and hire them. You hired someone competent, and you checked it if you could. If you can't, then that's fine. That meets that last one anyway. Then the occupier can put their hands up and say, I'm not liable, sue the independent contractor instead, not me. So this is essentially a defence for an occupier to essentially not be liable and pass the liability to an independent contractor instead. Okay, so an independent contractor, just remember, is someone that's come in and done some work for you, which could be a plumber, electrician, all sorts, lift engineers you saw from Hazeldean v. Door. Okay. So that's section 57. There's the last bit here on warnings and signs. And the occupier can discharge his duty by providing reasonable warning. And they can either be through express warnings, such as clear signs, as you can see there on the screen, or perhaps through implied warnings like fences and locks, etc. But there's one clear thing. We know this from Williams v. British Celanese, where a sign warning about a dangerous roof was behind a door. They said it has to be clear and visible for it to be a sufficient sign to discharge the duty and say, well, therefore it's fine. You did what was reasonable because you put a clear sign there. Okay, and obviously it also depends on the context. If you're talking about schools and kids and things, obviously the higher level of duty where kids perhaps can't read and things like that, you might have to do, much more than a sign. There are defences and remedies that can be relevant to this, so in terms of contributory negligence and volenti, so make sure you check out the videos which will be up soon on those, contributory negligence and volenti, and see where they could apply. And remember, the remedies that you'll be looking for in cases like this are either special damages or general damages. And remember, special damages are ones which are quantifiable, or quite often what they call pecuniary, which means you can calculate them easily or fairly easily. So that's medical expenses, physical damage to property, market value, injuries and things like that. And then finally, general damages, which are the unquantifiable ones, or non-pecuniary, which means that they're hard to actually put a figure on, such as pain and suffering and loss of amenity. And they're the sort of things you'll be suing the occupier for. So now we need to cover the Occupiers Liability Act 1984, and as I said earlier, this covers trespassers. So who is a trespasser? Well, a trespasser is someone that doesn't have permission or authority to be on the occupier's premises, or perhaps in some circumstances, lawful visitors can go beyond their permission because, for instance, a plumber fixing your downstairs sink decides to go upstairs into your bedroom without your permission, and there's nothing real reason for them to be up there. They would, of course, become a trespasser when they did that. So you can be a trespasser completely, or you can become a trespasser if you go beyond your permission. Okay, so there's the two distinctions there, is when you either are a trespasser or can become a trespasser. Now, traditionally, the laws changed massively here because traditionally occupiers owed no duty to trespassers whatsoever. The idea being, well, you're trespassing on land, tough luck. If you get injured or damage your property, tough luck. And we saw that really, and that was confirmed in the case of Addy v. Dumbreck, where a 4-year-old child was killed on the premises. And really, the point was they made in the case, well, the parents should have been supervising the kids, and they shouldn't be on the land in the first place. So the occupier on that premises was not liable, even though the child had died. By 1972, however, a case changed the law massively on this, and it was British Rail Board, or BRB v Harrington, and in this, there was basically a construction site or a sort of railway site, and they knew kids played in the area, and there were holes in the fences, and they left all this sort of dangerous equipment out, and a child basically came onto the premises and was seriously injured, or I think perhaps they even died. And actually, in this case, the court said, no, do you know what? There is a duty of common humanity, and actually, even trespassers, you need to do at least what's reasonable to keep trespassers safe. You can't leave all this dangerous equipment out when you know kids played in the area, for instance. So they said, you have this duty of common humanity to the people around you and in the community, so therefore no, you are liable. Now obviously that was case law, and the Law Commission then further reviewed this area and recommended what essentially led to the Occupiers Liability Act 1984. So whilst BRB v Harrington is a relevant case and certainly one you can include, the actual law we use today is not from that case, it's from the Occupiers Liability Act 1984, but it's a useful case to know in terms of this idea of common humanity, which you can certainly talk about in the essay. Now again, the sections you need to know, and we'll go through these, are section 1.1, 1.3 and 1.4, which is again a little bit confusing because they're slightly different to the ones in 1957 Acts, so it can get a little confusing there, but make sure you try and learn them if you absolutely can. But obviously the main thing is that you know the actual law. So the first thing is section 1.1, and in this, as I said earlier, the duty to trespassers is for injury only, so you are not liable for property damage. So if a trespasser comes onto your land and breaks their phone, they can't sue you under Occupiers Liability Act 1984 for their broken phone. They can only sue for injury. Okay, so that's a massively key distinguisher, and you can see obvious reasons why. Essentially you are trespassing, it's your fault, but if you're injured, fair enough. Now there's a test. So there's a test for this. The occupier only owes a duty if they meet these three parts of the test. So only if these three parts of the test are met will the trespasser be able to sue the occupier. So the first one is the occupier is aware of the danger or reasonably should have been. And we can see this in Rind v Asbury Water Park. In Rind v Asbury Water Park, they owned and operated a water park, obviously, in Asbury Water Park. And someone had come along and dumped a massive bit of fiberglass in the lake. Unbeknown to them, they didn't know it had been dumped in there, and of course they couldn't see it in the lake because of the colour of it, so they had no reason to know it was in there, and of course they couldn't regularly go through the water and make sure there's nothing in there within reason, because that would be very expensive and there's no way they could do that. And of course what happened was someone was of course injured when they hit that or on the water park, and they said no, they can't sue the occupier in this one. So it was a trespasser came onto the land, just to be absolutely clear. They couldn't sue the water park in this case because there's no way that they could have known or reasonably should have known that the danger was even there. So only if the occupier knows that the danger, or reasonably should have known the danger was there, will they be liable. So if we just go back to BRB v Harrington, they knew there was this dangerous equipment and left out on their premises at night and during the day and things like that. So they knew the danger was there. Okay. The second thing is the occupier has to know, or should have reasonable grounds to have known, that there could be trespassers entering the premises. So a good example of that is Higgs v Foster. On this, a police officer decided to take upon himself to enter the premises without permission. So he was a trespasser, and he fell down a sort of hole essentially and was seriously injured, which meant he had to take early retirement, etc. But in this, there was no reason for the occupier, to know that anyone was likely to do trespass. There was huge fences around it and locked fences and things like that. They'd taken all precautions they needed to do, but this police officer was able to give himself access and then was injured. So they said, no, you're not liable in this one. And again, if we apply that back to the last case, they did know or had reasonable grounds to believe there could be trespassers because they knew there were holes in the fence and the kids played on the area. So they did know, or could have, or should have known, had reasonable grounds to know that there could be trespassers on or entering the premises. And the final thing is the risks is one the court would expect the occupier to guard against. So actually this is like, it's something that actually the court will think actually you should have done something. So only if all three of these are met will the occupier be liable. And actually if you just look at the BRB v Harrington, it fits this perfectly because they were aware of the danger, they had reasonable grounds to believe that there could be trespassers on the land, and actually it is something they could have just fixed. The risk is one they could have guarded against by putting the tools away or making it safe or closing the holes in the fence. They could have done that quite easily and they didn't. So actually, sorry, you are liable. And that's how it would apply. Now, only if Section 1.3 applies, so you go through these and say, well, yes, they were aware of the danger or should have been, or they did know, the reasonable grounds to believe there was trespassing and it is a risk the courts would expect them to guard against. What the question then is, did they do what was reasonable? So even if you've got all these, they might still then find that you did what was reasonable. But that's the question. The occupier must do what is reasonable. So it's very much the same as 1957 to make sure that the trespasser does not suffer injury on the premise. Remember, it's only injury. And in doing so, they will look at a range of other considerations. So they will look at obvious dangers. So in Ratcliffe v McConnell, a woman jumped over a fence and dived headfirst into the shallow end of a pool. And they said, well, actually, clearly that's an obvious danger. So what could they have done to expect her to guard against that? So she couldn't sue them as a trespasser then because it was an obvious danger. And equally in Donahue v Folkestone Properties, someone dived in the winter at night, I think, into a harbour, and there was this grate there essentially which wasn't visible during normal swimming times in the summer and things like that, a normal day, but obviously wasn't covered by water at night in the winter when they expect no one to be swimming there, and they hadn't put up a sign or anything, was the argument. But they said, well, it's an obvious danger. Who dives into a harbour in the winter in the middle of the night? Like, they said, that's stupid. So they said, actually, no, that's not, they don't owe a liability to the trespasser in that case. They also don't expect you to spend a fortune making stuff safe, which really you shouldn't have to. So in Tomlinson v Congleton, BC, there have been problems with people swimming in a lake, so the council had decided to spend a load of money putting a massive fence around it and fencing it off. Because of budgetary cuts, they hadn't actually quite built it yet because they didn't have quite the money yet. And in that time, someone dived in and was paralysed essentially, and they tried to sue the council saying, well, you should have built this fence that you were going to build. And the court said, do you know what? No, they didn't actually have to build the fence. Like, that's a massive amount of money. They had signs up saying don't swim, no swimming and things like that. You're an adult, you shouldn't have been swimming there. It's an obvious danger. You dived in head first into it. It's your fault, not the council's. And equally, they will consider if the claimant was undertaking a foolhardy pursuit. So if actually the actions were dangerous, not the premises, then they'll look at that as well. And we can see that in Keown v Coventry Healthcare, where a child was balancing on a fire escape and then fell off it and was injured. There was nothing wrong with the fire escape whatsoever. It was not dangerous per se as a normal fire escape, and obviously you need it for normal law and rules around that. And they said it was actually the actions of balancing on the fire escape that caused the real problem here, not the fire escape, the premises themselves. And equally in Baldacchino v West Wittering, someone climbed up a beacon in the sea and dived off it, and equally it was them diving off it that was the issue, not actually, they weren't injured by the beacon themselves, the premises themselves, so therefore they will consider foolhardy pursuits. So generally the courts do take a really common sense approach with this, and it is largely quite often quite fair, so just make sure you take into account those considerations. And the final thing of note that's worth mentioning with trespassers is there's no distinguisher between children and adults. They're all treated the same, whereas with children there's a higher duty of care expected for children on the 1957 Act. There is no such duty in 1984 Act. All children and adults are treated the same under trespassers. Okay, so and moving on to the final bit, which is the essay points. The general point is that, there's been this duty to look after people on your property, a moral duty, for a very, very long time. It certainly goes back over a century, but actually you could look back to Roman and Greek mythology and religion, where it was absolutely a key thing that you looked after guests on your land, and actually there was a god around this, particularly around this, and actually one of the worst crimes you could do is kill or injure a guest on your premises while they were staying with you, hospitality and that sort of thing. So it goes back a really long time, this idea that you should look after people on your property. And as I said, it covers injury and damage, but unfortunately there are no definitions in statute, and we'll go through that into a bit more definition as to there's no definition of occupier or premises and things like that. That most of the definitions of what these things mean have had to come from case law, which seems really silly considering they did pass these statutes specifically, the Occupiers Liability Acts. Would it have been more sensible to have definitions? But of course definitions do limit you to those definitions, whereas not having definitions allows a bit more flexibility. In terms of the cases, the judges can make the decisions to what fits the cases, so maybe that's perhaps why they did it. Second thing is, well, who is the occupier? As we saw, it's really about control, not necessarily possession, and it's wide and uncertain. It can be zero or it can be multiple occupiers, which gives a lot of flexibility, but makes the law very uncertain as to who definitely is an occupier and who isn't. But as the positive is, there is a lot of flexibility there, and the courts can determine and find the right person. And quite often, a common sense approach, they'll be looking at who has insurance in those cases to weather the claim, really, because obviously they'd ideally like it to come out of insurance money, so therefore the claimant isn't actually, the defendant isn't actually directly affected necessarily there. And that's what insurance is, of course, for. Equally with premises, there's no statutory definition. Again, you question why there, but we know that it's included a very wide definition, perhaps too wide, including things like ladders and vehicles. And is that perhaps, should we really be counting those as premises? And you could say the law's gone perhaps too far there, but perhaps it's just trying to make sure that people are safe. And remember, that is an overarching point of the law of health and safety, is that ultimately the law is just trying to make sure that people are safe. And you could argue that they shouldn't be getting too involved in that, and they could argue it's a form of social paternalism, which is meaning the state getting involved in our lives and things like that, but actually ultimately it's probably a good thing they're trying to keep us safe. Lawful visitors, again, a very wide definition. We know it can include a whole range of people, from those with invitees, both explicit and implied, contractual permission, licensees, statutory right to be on the land, entry to communicate. So it's really good that it includes a wide array of people, including the entry to communicate thing, especially because that is a very common thing as well. But is it right that you can revoke permission and make someone a trespasser simply from a sign? Is that very fair? But equally, if it's your land, you should be able to control who comes on your land, and surely that's your right as well in terms of human rights, and also just going back in terms of history and things like that. Number 5, the duty of care. Remember, you have to do what's reasonable, both in the 1957 Act and the 1984 Act, to keep the visitor or the trespasser safe, essentially. But, what does reasonable mean? Obviously, people will have different opinions of that, but we can see really clearly that the courts have, thank goodness, taken a common sense approach, which doesn't cover everyday slips and trawls, and it has to be a serious danger. And we saw in cases like Kia Pasha Takeaway, Supreme, and also Rochester Cathedral v. DeBell, that really they do take a common sense approach, and that is a very strong point for the essay, that the courts have taken a common sense approach to this and really don't expect premises or occupiers of premises to go above and beyond. As long as they've done what's reasonable, that is enough. You can't expect them to be, because it would otherwise, and this is absolutely 2 key points you want to make, it would open the floodgates, and it would mean that occupiers had to spend fortunes on their land to make every single thing safe, which they just couldn't possibly do. So 2 key things there. You'd have to spend loads of money, and it would open the floodgates, and they don't want to do that. 6, children. We know that under the 1957 Act alone, not the 1984 Act, but 1957 Act, they're owed a higher duty of care. But at what age? What age does the parent stop being liable for supervising them, as we saw in Phipps v. Rochester Corp, and actually it becomes the occupier? And we don't know, and that's again an area, a grey area in the law that we're not really sure, and seems to be decided on a case-by-case basis. Equally, it's fair that tradespeople or tradesmen are expected to protect themselves as part of their trade or profession, as we saw in Rolls v. Nathan with the chimney sweeps. That is fair, because you shouldn't have to tell a tradesperson. You shouldn't have to tell a tradesperson how to do their job. They should be expected to come in and take the precautions that they need to take in as part of their profession. Equally, around defences, number 7, are warning signs sufficient? Should it be sufficient that you've just put a warning sign up? And again, that will be determined on the situation. So, for instance, if it's children or people that can't read. But of course, defences, the fact that defences like contributing negligence and volenti apply is a really good thing. And obviously, you have to know those definitions of what those are to really talk about this in depth. But it's about attributing blame, and that's a good thing. The fact that the courts are trying to look, well, who is actually to blame, and is it both people, is it both parties, and therefore they'll divide up potentially the damages accordingly based on contributing negligence for that. Under number 8, Occupiers Liability Act 1984, there are very distinct limitations, aren't there, as to when the occupier can be liable, or will be liable. So, for instance, they have to be aware of the danger, or should have been reasonably aware of the danger and the trespassing. And that final bit about the court deciding that it is a risk they should have guarded against gives the courts a lot of power to decide whether it is fair in that situation or not to hold that occupier liable for the trespasser being injured on the land. So it gives the courts a lot of power to really argue the case and look at it on a case-by-case basis, having those 3 limitations there, rather than just saying you're liable for every trespasser. Interestingly, number 9, this point around common duty of humanity, it's a really nice phrase around that idea of community and the fact that you are expected to look after people in your land, even if they are trespassing. And we knew that obviously came through from Harrington, and then the Law Commission, and then the Occupiers Liability Act, which is actually a really big strength. So often we're criticising laws because they're just made by common law and no one's ever really had a say on it. But in this case, the judges changed it, the Law Commission reviewed it, and the Occupiers Liability Act from Parliament made it the law. So we have a really nice chain of lawmaking there, which actually is the proper process. Finally, number 10, we know that obviously the reasonable test applies again to the 1984 Act, and with that comes uncertainty, but a common sense approach. And you can see those with the other considerations around foolhardy pursuits, not expected to spend a fortune, obvious dangers, and the fact that the courts do really, again, take a common sense approach and include these things. But the only thing that's not covered is that children are treated the same as adults, and should that really be treated as the same and as the case? So finally, scenarios. Obviously, when the first step you need to do is identify whether the claimant was a lawful visitor or a trespasser and why, and that determines which act to apply. Either way, you always then want to cover who's the occupier and why they are the occupier, what the premise is, and why the claimant is a lawful visitor or a trespasser, before you then go on to apply either the 1957 Act or the 1984 Act respectively, determining first for 1957 whether they did do what was reasonable, and then any exceptions around independent contractors, tradespeople and things like that, and children, and perhaps under the 1984 Act going through the limitations first to determine even if they do owe a duty or not, and then if they do, whether they did what was reasonable or not, and then considering any considerations into whether that was reasonable overall. I hope you found that useful, and if you did, hit subscribe on YouTube, and there'll be more videos on tort and contract law coming up soon. Thank you very much.